You won't believe it. We're back again here at allpointstv.com, and we're back at the first day of July, the month of the celebration of the founding of the nation, July the 4th, 1776. And we'll be making some comments, hopefully, about that. If not in this session, because I'll have a lot of things to talk about in this session, we will certainly be doing something with that next week. Before we get into any of the comments we want to make today, John wanted to play a piece that he's been referring to over the last couple of days. And so, John, you're going to introduce that?
Yeah, this is, I guess, Joe Pegg's his response to this overturning the Supreme Court's recent overturning of the Chevron deference thing that was established in 1984. And I got to be surprised. I want to hear your response, but what your initial response surprised me. But I'm gonna play it, and then you'll be watching it. And people will be able to watch the video clip as your response to it goes up. It's relatively short, folks. It's not even 3 minutes, I don't think. So okay. We'll start from there. Okay.
Okay.
Are you seeing the massive freak out here and on other platforms about something that does affect you directly? Actual lawyers who had to go to law school and get a law degree are either lying or they don't understand Chevron deference. Chevron deference was a ruling back in 1984 that said if a law is too vague, the administrative state, in other words, unelected bureaucrats in those alphabet agencies and the executive, would be able to decide policy regarding that law. In other words, the executive branch got way more power than it should have. You've got three co-equal branches of government. The executive, that's the president, vice president, and the administration. The legislative, that's the Congress, Senate, and House together. And then the judicial branch, which is the courts, the highest court, of course, the Supreme Court. Well, the Supreme Court decided a couple of days ago that Chevron deference is not constitutional because it gives too much power to the executive. In other words, the FDA, the ATFE, the DHS, all of these agencies got to decide how to enforce through policy any laws that were passed by the House, the Senate, and then signed into law by the president. That gives the centralized government, the administrative state, mostly people who are unelected, the opportunity to lord over you and me, and this dials that back. Listen, if the bill isn't good enough, if it's too vague, make the Congress, who represents us, we actually have a say, make them pass some bill that makes sense and that is not vague. And then if it's too vague, then the executive cannot sign it into law, and then it doesn't become law. But setting policy, I'll give you a quick example, just a quick one. The DHS, Department of Homeland Security, has control of the Border Patrol. The Border Patrol under the last president followed the law because the president said, we have a law, just follow it. And then that shut down the open flow of people across the border. This DHS under this president said, forget the law. My policy is just let everybody in, give them asylum, give them parole, and we'll act like it's not happening. Well, that couldn't happen unless we gave these centralized government administrative people the opportunity to ignore law and set policy. This will dial that back. This means we have a say, more say than we've had for a long time, in exactly what the laws of the land are. You now know what Chevron deference is. Don't believe the BS you're hearing from people who are clearly biased on this platform. This actually balances out the power the way it should have been the entire time. Come on.
Okay, John, that's the clip right there, right?
Yes, it is. That's from Joe Pegg's, I guess.
Yeah, Joe Pegg.
I've heard the name. I think I've seen a couple of things before him. I don't know where he stands, on the educational level wasn't he some federal agent or something himself? Or?
I don't know if he was a former agent or not. I know he's a host of the radio program, the Joe Pegg radio show that comes on. I think I have listened to it on Saturdays, and he's sometimes been the co-host of some of the persons that will be gone, maybe on vacation or something. He comes in and subs for them. I'm aware of him because I do listen to conservative radio. I don't think that this is one of his best shots, but I do understand the claim he's making. They all are making these kinds of claims. I'm going to read something to you that will. John was surprised by my reaction to it as I watched right before the show started, and I want to read something to you that will explain why my position would be a little bit different than what Joe Peg was doing in that clip that you just saw. I'm going to go back to a court case in 1919, the Sheikh versus United States case. Is that? I hope it's not. Hope it's not playing again.
No, that was something on my phone. Sorry. Yeah.
Okay, I can only take that one. Don't play that again. I'm going to read something to you as a background to what I'm going to be saying about that clip. And it has to do with the Schenck versus United States case that came up in 1919. And it was written by the celebrated jurist Oliver Wendell Holmes. You've probably heard the name because Holmes is the one that said that you can restrict certain parts of the First Amendment, which says that the Congress should make no law that would restrict free speech. And the court had Oliver Wendell Holmes write in what was unanimous verdict in 1919, the Schenck versus United States case, where Oliver Wendell Holmes invented out of whole cloth this whole idea that it can be restricted because you cannot scream fire in a crowded theater. As if anybody shouted fire in a crowded theater. That was not even what the case that was brought to the court by Schenck that appealed his case to the Supreme Court because the court had said that, and let me read it to you, and then we'll talk about the implications of the court and how the court is implicated in what Joe Peg was talking about, and which is why I'm going to take some exception to what Joe Peg said. I do respect him, but these are not constitutional scholars that we're talking about. And you won't believe me when I tell you, I know you don't believe me when I tell you that there's no scholar in this country on this level. And they prove it every day by the things that they're saying. Anyway, here's the background to the Schenck case. And I'm going to read a long passage here that you can find in the Wikipedia that I drew this down from, and I'm going to read a very long part of what is said there, but you can go and read it from the Wikipedia for yourself. Schenck was the first in a line of Supreme Court cases defining the modern understanding of the First Amendment, Supreme Court Justice Oliver Wendell Holmes wrote the often cited opinion, the United States entry into the First World War had caused deep divisions in society and was vigorously opposed, especially by socialists, pacifists, isolationists, and those who had ties to Germany. The Wilson administration, Woodrow Wilson administration, that was administration during that time period, Woodrow Wilson had been elected in 1912 at a time when the Republican Party was divided between the former president, Theodore Roosevelt, who was running at this point on the Bull Moose ticket in 1912, and running against William McKinley, his successor, the Republican Party candidate, and the split of the Republican Party into two wings, the Bull Moose wing of the party and the Republican wing of the party, the Republican mainstream part of the party. And that split caused a division that allowed the Democratic candidate, Woodrow Wilson, to come in and win the election in 1912. Wilson's running again in 1916 for re-election. And it is during that time period that you'll have the Schenck case coming before the Supreme Court, because Wilson had run, as you remember, on a campaign of he kept us out of the war, which he did, of course. The war had started, World War I started in 1914. And the U.S. had not joined the war at that point. Wilson running on a campaign to be kept us out of the war in 1916. And yes, when he was in fact inaugurated March the 4th, 1917, he kept us out of the war for a whole month. Because the U.S. got involved in the war April the 6th, 1917. So a month after Wilson's second inauguration, Wilson, who had kept us out of the war and was running upon that campaign, we were out of the war for a whole month. After his inauguration, being inaugurated March the 4th of that year, we got into the war April 6th, 1917. So now we have the U.S. involved in the war, and there are some persons that are opposed to the U.S. entry into the war because of Wilson's campaign. He kept us out of the war, and and after campaigning on it, there are some of the ones that are now looking at this finessing of the public again, as they've been doing for how long has that been going on, and saying the government talking out of both sides of his mouth. So in the first case arising from the campaign to come before the court, Balsa versus United States, South Dakota farmers had signed a petition criticizing their governor's administration of the draft, threatening him with defeat at the polls. They were charged with obstructing the recruitment and enlisting service and convicted. When a majority of the court voted during their conference to confirm the conviction, Holmes quickly drafted and circulated a strongly worded dissenting opinion. Now listen to Holmes in this court case. Real obstructions of the law, given real aid and comfort to the enemy, I should have been glad to see punished more summarily and severely than they sometimes were. But I think that our intention to put our all-out powers in aid of success in war should not hurry us into intolerance of opinions and speech that could not be imagined to do harm, although opposed to our own. It is better for those who have unquestioned and almost unlimited power in their hands to err on the side of freedom. This is Holmes talking in relationship to Balsa versus United States in 1918. Rather than proceed in the face of Holmes' biting dissent, Chief Justice Edward Douglas White set the case aside. Word of the situation evidently reached the administration because it abandoned the prosecution. White then asked Holmes to write the opinion for a unanimous court in the next case, one in which they could agree, Schenck versus United States. Holmes wrote that opinion and wrote again for a unanimous court, holding convictions in two more cases that spring, Forward versus United States and Debs versus United States, establishing the standard for deciding the constitutionality of criminal convictions based on expressive behavior. Holmes disliked legislative style formulas, and he did not repeat the language of clear and present danger in any subsequent opinion. However, Schenck alone, accordingly, is often cited as a source of this legal standard. And some scholars have suggested Holmes changed his mind and offered a different view in his equally famous dissent in Abrams versus United States. The events leading to the assignment of the Schenck opinion to Holmes were discovered when Holmes' biographer, Sherlock Novick, unearthed the unpublished Balsa opinion among Holmes' papers at Harvard Law School. Schenck versus United States was a landmark decision of the U.S. Supreme Court concerning enforcement of the Espionage Act of 1917 during World War I. A unanimous Supreme Court, in an opinion by Justice Oliver Wendell Holmes, concluded that Charles Schenck and other defendants who distributed flyers to draft-age men urging resistance to induction could be convicted of an attempt to obstruct the draft, a criminal offense. The First Amendment did not protect Schenck from prosecution, even though, listen carefully to this quote here, in many places and in ordinary times, the defendants, in saying all that was said in the circular, that is what they passed out in opposition to the draft, that all that was said in the circular would have been within their constitutional rights, but the character of every act depends upon the circumstances in which it is done. In this case, Holmes said the words used are used in such circumstances and of such a nature as to create a clear and present danger that they will bring about the substantive evils that Congress has a right to prevent. Therefore, Schenck could be punished under the claims that the First Amendment could be, therefore, in a sense, suspended because the circumstances that it was now played out in was such that there would be harm done if the freedom of speech was in fact exercised under the First Amendment because of the claim being made here of the of the effect it would have upon the war that had now been engaged as the U.S. got involved in World War I. The court, following the reasoning to uphold a series of convictions arising out of prosecutions during wartime, but Holmes began to dissent in the case of Abram versus United States, insisting that the court had departed from the standard he had crafted for them and had begun to allow punishment for ideals. In 1969, Schenck was largely overturned by Brandenburg versus Ohio, which limited the scope of speech that the government may ban to that directed and likely to incite imminent lawless action, et cetera, et cetera, et cetera. Now, the reason why I read all of that is because wherein the claim is now made that there's such a latitude that these laws being passed by the administrative state are so wide that it does not allow for the specific enforcement and constraining the government, because it's such a vast area they created in the administrative state by lacking the specificity, the specificity that is now being made in the fiat laws that are being made right now by the administrative state, which Joe Peg and others that are making these claims do not understand that this wide latitude is because of the dismissal of the specificity of the Constitution of the United States. And that goes back to the Schenck case of 1919 in the celebrated Schenck versus United States case, where they're celebrating this nonsense by Oliver Wendell Holmes, who wrote the majority opinion in the Schenck case in 1919, where he made up this claim that you can suspend the First Amendment idea of the freedom of speech because you cannot holler, cannot scream fire in a crowded theater, and therefore using that logic to then say that speech can be restricted because you can't do that. And so everybody's bought into this claim made by Oliver Wendell Holmes, who's supposed to be this great jurist on the Supreme Court during the time period when this ruling was in fact made by the unanimous court in 1919. Now, let me tell you this. Everybody is celebrating Oliver Wendell Holmes as one of the great jurists in this country's history. I don't celebrate Oliver Wendell Holmes. And if I said what I thought about him on the air, I've been on the air now for 12 years at this studio. If I said what I thought about Oliver Wendell Holmes, they would, in fact, ban me off the air for the next 12 years because I don't have respect for Oliver Wendell Holmes, although I do have some respect for what he said in the claim he made about what he said about Toussaint the Overture and his placement in history. I do agree with him on what he said about the Haitian leader of the Haitian Revolution in 1791. We're on the same page with that. But in terms of being on the same page with what Oliver Wendell Holmes said in the Schenck case, Schenck was talking the same nonsense that Joe Peg was talking about. And I take exception to what both of them said. And that starts out because of what Oliver Wendell Holmes said. Nobody in the Schenck case had hollered fire in a crowded theater. And I agree that you cannot holler fire in a crowded theater because of the danger it would create in terms of the panic and so on and so forth if you're hollering fire in a theater and there's no fire. I agree that you cannot do that. But that does not fall under the terms of the First Amendment. That comes under the terms of a contract that's signed between the theater goers and the contract that is signed with them buying the ticket. You're not writing your name out on the ticket. What you're doing is buying the ticket, and by buying the ticket, you're buying into a contract that's signed between the ticket owner and the person that is the owner of the opera house, of the theater house, where you buy the ticket with the understanding that you're going in there to see a movie or to hear the opera or sing something else, maybe the rap concert, where you have a contract that they are going to show you the movie, the concert, or the rap artist on the stage, and you're buying it with that understanding what the contract will be as a contract issue. And if they stand up in their theater and start hollering fire and they violate the terms of that contract by doing that, because they are violating the terms in which you bought the ticket, that contract is being violated. But it's not a free speech issue that Oliver Wendell Holmes made it as a way of constraining the First Amendment of the United States. If I tell you what I think about Oliver Wendell Holmes, you're going to throw me off the air for the next 12 years, because this man is the reason why you have the administrative state. Because it was not Joe Biden who made the claim, and he made this claim, but he's not the first one to make the claim that that when Joe Biden said that no amendment is absolute, he's not the first one to make that claim. The first one made the claim is the Supreme Court. But it's ridiculous ruling that it made in the Schenck case in 1919 that said that you can limit free speech because you cannot holler fire in a crowded theater. This man pulled this notion out of whole cloth so as to make it appear reasonable that the First Amendment can be constrained. Let me tell you something. All you scholars, you so-called scholars, constitutional scholars, you cannot constrain free speech in this country under any claims that are made, because the Constitution says shall not. You understand the absolute aspect in which the Constitution is speaks? If you say shall not, it means it shall not be done. Now, the devil made me do it idea that you have, which is that the devil make you do it. The devil doesn't make you do anything. You have choice here. And if someone is passing a circular out saying that you shall not go to war, he doesn't make you do that. You have a choice in the matter to do it. And if you make a choice not to do it, that choice is a choice that you made, and that is not because of the exercise of speech. is because of you exercising the option of going or not going. It's the same thing people have about the exercising of they say the exercising of choice in terms of my body, my choice. Yeah, it's your body, and you do have a choice in the matter. You have a choice. The choice is not at the point of the abortion. The choice is at the point of the act that you created, the choice you engaged in terms of that which created the child. You cannot suspend, therefore, this is what Moss is saying, and there's no scholar in this country who's going to come behind me and say anything else. You scholars, what you're talking about, I got to tell you something. You shut up. Because most of you guys are talking, most of y'all, you're out of your head.
Okay, but I'm watching. I mean, I'm really surprised by your reaction to this.
I'm just telling them what Constitution requires. Go ahead.
Okay, about the Chevron. I mean, I personally, I was like really applauding this because it's like I think that I think they basically there's inconsistency into one, like he alluded to. There's inconsistencies between two different administrations' enforcement policies, and I have a problem with that. I mean, if they feel the need to pass a law, they should either pass the law consistently and keep it enforced consistently from the variance of all the administrations aside. That should be uniformly and consistently enforced. And that's what I think that if we give too much power to these groups to decide how much power they're going to have over us. So I was kind of surprised by your reaction.
Yeah,
to it,
but our disagreement is not that there's too much of a latitude in the administrative state in terms of this bus you could drive through the general claims that they're making. The question I'm raising here is what produced that administrative state that allowed them to drive a bus through this claim that they're making through the administrative state, making these perverse decisions. It's the Supreme Court that would refuse to go along with. The Constitution says exactly what it says, and it means what it says in the absolute terms in which the Constitution speaks in. The Constitution doesn't speak in the voice of shall or should. The Constitution speaks in the voice of shall. Shall is that the Congress shall not make any law that abridges the freedom of speech in this country, as if the language is under certain terms. Therefore, the word shall is should. And I'm saying that's where the problem is. The Supreme Court opened up the avenue through which you have this administrative state that's created. And that's what the problem is. The problem is not the problem is the administrative state, but don't forget what creates administrative state. The court making it appear that shall in the Constitution is should, is not should, it shall not. The court is saying that should is the command language in the Constitution. Is not the command language. The command language is Congress shall not do it. Now, why does it say Congress? You scholars listen carefully, because I'm gonna tell you something. You may think you're on this level. All of you, you're not on this level. None of you are saying this. None of you are saying what I said in my post today on Facebook. I said in open because I got to tell you something. This is the area I'm trained in. And none of you scholars are trained. I thought you were trained in this area until I began to understand your training. Your training is in law, and therefore your scholarship is in the parroting of what the Supreme Court has said. I have almost zero. I do have something interesting because it is, the governing aspects of what we have in the country. So I have to pay attention to it. I don't respect it. Because if it contradicts and contravenes what's said in the Constitution, then I can't go with that because the Constitution is a law of the land. It is not the Supreme Court, which these lawyers keep quoting the Supreme Court and giving the authority to the court rather than giving the authority to that which the court is supposed to be interpreting. Their role is an interpretive role. You understand that? You scholars, you understand that the court is assigned by the states as the interpreter of the Constitution. They don't create the Constitution. It's created by the founding fathers of this country.
Well, see, that's you and I are disagreeing on now, or not seeing it, because I think this overturning of this doctrine that was put in 1984, referred to as the Chevron difference, is actually basically returning to the original intent of the founders. That's what I'm seeing it as. That's what I'm having. I'm really puzzled by this.
The original intent of the framers is shall not. You cannot make a law that makes an addendum to shall not. John, look, let me say this. You cannot amend the original intent of the Constitution of the United States. They think you can amend it. You cannot amend the original intent. And the reason why you cannot amend the original intent is because the original intent is the agreement that the 13 states, the 13 original colonists, came together to create the United States. It's out of the agreement they made at the Constitutional Convention in 1787 that they have the terms made in the Constitution. So the first 7 articles of the Constitution is the Constitution. The amendments to it is that's added to it, but it cannot add to it to contravene that which was in fact agreed to. The scholars don't understand this. And I'm telling you, you cannot amend the original intent of the document. It cannot be amended. So therefore, there are things added to the document that are itself unconstitutional. I'm writing this, and every scholar in the country is wrong. Let them come on the air and defend it if they agree that they are right and I'm wrong. Then come here and defend that in front of the public. They don't come out and challenge me on this because they're not qualified. I'm telling you the truth here. I'm the only scholar in the country saying this, but no scholar in the country can contravene what I'm saying. The administrative state is created by the Supreme Court that allowed for the constraining of the specific and clear language where the Constitution is mandating certain things in place. The Constitution does not speak in the voice of should or can, because it is a document that commands the government to act a certain way. It does not give wiggle room for this should or hopefully or can. It doesn't allow for any of that. The word is shall. And you have to ask yourself the question, why is it that in every one of the amendments, you scholars listen carefully, the reason it speaks with the word shall in every one of the amendments, except Amendment 10, the word shall is consistently shall. It keeps saying that word over and over again. Why? Because of what was written in the 51st Federalist paper that was written by the great lawgiver of this country, James Madison.
We have a couple questions here, okay?
Go ahead. I love questions because I'm saying things that's very new to all the ones who are listening to what I'm saying here.
Okay.
But the scholars are not going to come behind me and say anything different. If they do, let them do this publicly. Why don't they come out and challenge me publicly?
Okay. One of the questions is, do you think it's a good idea? It's a good thing to tie up Congress and court trying to get their rules and regulations passed.
If Congress was doing its job, which is not doing, it would have, in 1919, you see, the court has impeached 3 presidents. It's impeached 15 federal judges. 6 of them have been removed from the bench. It should have been a lot more of them. And some of the ones making these stupid rulings now, like Merchant is a state Supreme Court. But if they were, in fact, federal members of the court, it should be a lot more of them, because look what they're doing in terms of putting Trump on trial.
Okay, that's a follow-up question. I will lead into this one. Okay. Would you be okay, Mr. Moss? Would you be okay with Biden's Attorney General Merrick Garland creating a special prosecutor, Jack Smith, to go after President Trump without getting the permission of Congress? So I mean, that's the reader, the listener.
Look, I respect the question. It's a great question. I'll tell you the reason why I'm laughing, because if he were not in office and I was not putting myself in jeopardy by saying this, I would, if he were not in office and I was not in jeopardy by saying this, I would slap I would slap this man on both sides of his face, because this man, I'm talking about you, Merrick Garland. They were going to put Merrick Garland on the court. This is going to be an appointee of Barack Obama, the illicit president of the United States, by the way, who usurped the position of blacks in this country by running for president, by standing on the steps of the state house where Lincoln and Douglas were in a debate in 1858. He stands on those steps as a usurper, as if that had anything to do with his lineage. This man's black lineage goes back to Kenya. You understand that? He stands on the steps as if his grandparents, great-grandparents, and great-great-grandparents were out there in those slave fields picking that cotton. This man jumped in front of that historical legacy as if that had anything to do with his lineage in this country, and then acted as if the U.S. was ready now to make a turn for the better in terms of race relations, and turn to this imposter and turn to him to run for president, as the country is trying to get over some of the egregious things that happened in the racial politics of this country. This country is trying to get over the hump, and this man brought him back into it full circle, making the country even more split and divided than it was before he got in office. I condemn this man and indict him on the air, and he better not say anything about the Constitution either. He's supposed to be a person that finished Harvard University in law. Look here, I got to tell you something. He's not on this level either. He better shut up as well. Merrick Garland and this two-bit hustler that's in the administration along with him, Alejandro Mayorkas, who's over Homeland Security. These guys, if I were in charge of the Congress, and don't forget the Congress right now is run by a majority of the Republican Party members. And impeachment, even if you can't get a conviction, the impeachment starts in the House of Representatives, and they have a majority of Republican members, Republican Party members, I should say, not Republicans, Republican Party members in the House. And why is there no impeachment of Merrick Garland, who should have been impeached for the things this man is doing, appointing a prosecutor to prosecute the president of the United States, which cannot be done.
Oh yeah, but
under the Constitution of the United States.
Okay, you and I seldom disagree. Okay, so seldom.
Okay, let's go with it.
Okay, but see, what I'm hearing from what this recent overturning of this Chevron, deference doctrine, actually now Paul calls that kind of action into serious question if they have a right to try to enforce it in that manner. And I'm against anybody doing ad hoc ability to try to create some more power than they were originally granted. And I think we gave them too much power. I think this is kind of turning back the clock. I have to agree with what I hear from Joe Peggs. I mean, and I normally don't. I don't like I like to get anything that gives us power, gives more power where we can question or slow down the process, to impede the process of passing new laws is a good thing. And I'm kind of surprised by your reaction.
No, John, you're missing my point. I'm not arguing that is not true what Peggs said. What I'm arguing is that that what gives license to the administrative state is the Supreme Court and the federal government that's going along with the fact that the Constitution does not mean what it says.
See, I can agree with you on that.
Okay, but you don't have the administrative state if you go and enforce that idea.
But see, the thing is, that's what I'm thinking. This kind of puts it back into that framework. But that's what I think that is. Yeah.
But you're going to have this kind of widening of the law and the creation of administrative state if you don't follow the Constitution. That's what these scholars don't understand.
See, I really seriously agree with you. That happened, but I mean, and that shouldn't have never happened. We've allowed that.
How did the administrative state get created? How did you have these alternatives to the Constitution? They created the government, the three branches of government: let's start with this. Because I will tell you something. I'm going to argue this in the name of the framers of the United States of America. I'm going to argue their position. And I'm the only one arguing their position. I hear all of you on television. You're not arguing their position. I listen to all of you. They had Wu on Life, Liberty, and Levine last night of the U of C Berkeley branch of the law department there. And I listened to him, and I listened to Mark Levine and some of the others. And I got to tell you something. They have good intent, but that's a part of that pavement of that road that we have in this country. You have got to understand what the framers were doing in that room. And what the framers were doing in that room, as I was saying earlier, is in 51, the Ferris Paper 51, that was written by the great lawgiver, James Madison. James Madison's the one that said that if, in 51 he said this, if men were angels, you would not need laws. And if the government was made up of angels, you would not need a Constitution of the United States. So then the Constitution is written so as to make the government, command the government, demand that the government behave. And the government behaves if it understands the absoluteness of the terms under which it is in fact constrained. There's no wiggle room here. The word shall is a commanding word, and there's no way you can wiggle out of it. And what they did in the Shemp case, the court was talking about if you scream fire, you can restrict speech. You cannot restrict speech because you scream fire. What you do is take him out and put him under arrest because the contract has been violated. You understand that? This is not even a speech issue. That's why Oliver Wendell Holmes needs to be set down, and rather than celebrating this man, to understand this man was dangerous. That's what I'm saying. You settlers are saying what? I'm saying Oliver Wendell Holmes is part of the endangerment of this country by the Supreme Court. And as I was typing out my article this morning, and let me calm down here, because don't get me started. As I was typing out my article this morning, the Supreme Court did another misdirection. And what did it do in this misdirection? By having this court case brought to the Supreme Court of does the President of the United States, talking about Donald Trump in this case here, does he have immunity for the decision he makes as President of the United States, with the defense team of Trump claiming that if the president does not have immunity, then it restrains the president from acting because he has to look over his shoulder to wonder if he makes this decision when he steps down from office, can they then come at him because he made a decision that later on they will find some objection to. So it opens up that can of worms. That's what they're saying, is the defense of Trump is saying that that this is bigger than Donald Trump because it opens up a can of worms for all the presidents thereafter if they say there is no immunity. Well, let me just say this to the court, and which bounced the issue because the court is gun shy and it can be manipulated based upon certain things that will that goes on politically. The court can be manipulated. I'll give you one example of that. The court was manipulated in 1937 when Franklin Delano Roosevelt threatened to pack the Supreme Court in 1937 because the court was in fact ordering, was threatening the court by it striking down the New Deal, which it should have struck down because most of the New Deal legislation was unconstitutional, and the court was striking it down. But when Roosevelt responded by the threat of packing the Supreme Court, with every one of the members over the age of 70 would add judges, making it an age thing, would add a judge for every judge over 70 to the Supreme Court, and that threat was enough to make the court back down, and they did not rule that another act of the federal government, the executive branch, was unconstitutional until the 1990s. That's how gun-shy the court was from 1937 to the 1990s. It never struck down another act of the federal government from that point until the 1990s. Why was that true? Because the court can be intimidated. And I'm telling you this, I'm not intimidated. The Constitution of the United States says what it says, and when you say that there's wiggle room in the word shall, you create the conditions for the administrative state. That's what I'm saying. And the administrative state, where they're saying can drive a bus to it because it's too much wiggle room, the question is, how was the wiggle room created? That's what I'm raising here. The wiggle room is created by the court making this silly, obnoxious ruling that they give Oliver Wendell Holmes credit for, and so on and so forth, when the man is talking out of both sides of his mouth at the turn of the 20th century, saying that you can constrain speech when you cannot constrain speech, because speech is also an absolute in terms of the guarantee of free speech in this country by the Constitution of the United States. One of the inalienable rights that you have, that the court has made a constitutional right in terms of the constraining of that. And so as I'm screaming here, because I'm very adamant about what creates the administrative state, because the administrative state should not exist. The bureaucracy that you have to deal with right now, called the deep state, it only exists because the three branches of government have given license to it.
I can agree with you that it should not exist, like the way it's going on. And that I've always questioned, and people get angry at me asking, why did we allow this? And it's because when I was in 1984, when they came out with the Chevron deference thing, they originally installed, now they just overturned. I never heard anything about this in the press that I can recall. And of course, we didn't have Google search. We didn't have the 24-hour, 24/7 news thing that we have now. I was heading towards that back then. And besides, I got to admit, I was working a lot, so I basically probably would have ignored it if I had heard it. But it was serious, definite. It was a seriously detrimental, procedure that they allowed to happen. And I think what it is because it's a good old boy network. They're in us on this together, and they trust each other. They got this copacetic situation. It might work out in that scenario, but basically they leave it in place, and then now it's become part of the culture. And now you got all these people set up with that in mentality. The new hires coming in, that's the way the things are run. They just assume they roll right into the next, the next group of people coming into it, just roll right into that, that mentality.
Yeah. What is the reason that you have Jack Smith not appointed by the president, appointed by Merrick Garland? How did that happen? The president appoints members to his cabinet so that it can be checked by the Senate based upon the Constitution. How did Merrick Garland get involved in creating a position for Jack Smith, who is going after the president of the United States, which you cannot do that? How did that happen? Because they created the administrative state. The question is, how did the administrative state get created? Because the court created this vacuous space. Anytime you create a vacuum, you have people running into the space that's been created. But the word shall does not allow for the space to be created. So the administrative state, we all complain about the administrative state, but we don't understand why you have the administrative state. The federal government is made up Article 1, Article 2, and Article 3. It has three branches of government. You know what they are. Article 1, the legislative branch. Why is that the first branch of government? Because it is a parent of the under the Articles of Confederation, it's a parent group because you didn't have a executive branch. You didn't have a judicial branch. You had a single branch of government under the Articles of Confederation. Therefore, the Constitution says Congress should not. It's speaking to that which had prevailed before the Constitution was in fact drawn up. But they're drafting another document now. But it's not a document where you cast everything in the articles to the side. You're building upon it, and because you're now trying to do what's in the preamble to the Constitution, where it says, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain this Constitution for the United States of America, to themselves and to their posterity." Therefore, what they're creating is not to be coming behind 9 people wearing these burial robes, these black robes, which are funeral garments, which they're using to bury the Constitution on their garments as they make these. And don't get me started on that. I'll definitely be banned. But these rulings, they have nothing to do with the Constitution of the United States. You can't see they remanded this case before them back down to the court. The court today, as this happened today, the Supreme Court sent this immunity case back down to the lower appellate court and asked them to specify in certain areas. Does the president have immunity in this area? Does the president have immunity and want them to specify so they can more specifically see what the appellate court said in order to strike it or to rule upon that in the different areas in which he was making his ruling. He wants the lower court to clarify so it can now move into the immunity claim. Let me tell you this. This is Maul speaking. All you scholars, what you going to say about this? There is no presidential immunity. I don't want to do any skirting around it because it doesn't exist. But, and it's a big but here, but there is a protocol in place where the president can be held to account. And that's in Article 1, Section 3, Clause 7 of the Constitution of the United States. That is saying the Article 1, Section 3, Clause 7 protects the separation of powers. At the same time, it does not allow for any branch of the government to go out of control without being held to account.
Well, here's a question that might follow up with that. You might want to follow up. I mean, it's a good segue.
Follow up on it because I'll tell you this: there's no scholar can come behind me and say anything, and they better close their mouth.
Okay, we've got a question here. Can you have him explain, Mr. Moss, explain how originally the Supreme Court had no real power and how it got its power?
By making these stupid rulings that are not constitutionally. You see, it's what Thomas Sowell writes about in the constrained vision. He talks about the unrestrained vision and the constrained vision. The government, and I'm talking about all governments, they refuse to accept the constrained vision. The Constitution speaks in the constrained vision. The government power, it refuses to bow down to the constrained vision, which is the vision of the framer. That's why the word shall is used in the Constitution, because the Constitution is speaking in the constrained vision. Government wants to speak in the unconstrained vision. That is to say, its power is not to be constrained. Yet the Constitution is there to restrain it, to tell the government you cannot do what you want to do. That's the difference between the Constitution and those who are now interpreting the Constitution. And what they've done here is interpreted the Constitution so it stops to mean what it says. Go look at the Constitution and ask yourself this question. Why is it in every one of the amendments of the Constitution, and there are 27 amendments, every one of them except the 10th Amendment has the word shall in it? Why is that shall there? Because it's the constrained vision in which the Constitution speaks. They want to speak in the unrestrained vision, where we can find, we can say things like, you can restrain speech because you can restrain speech because you can't holler fire in a theater. Well, you can not holler fire in a theater, but that's not about speech. It's about a contract. It has nothing to do with freedom of speech. You can not tell people they can't pass out a circular. This stupid stuff right here. This stupid stuff right here. This is this right here. This is right here. The First Amendment did not protect Schenck from prosecution, even though, quote, this is a quote now, in many places and in ordinary times, listen close, the defendants, in saying all that was said in the circular, would have been within their constitutional rights. But the character of every act depends upon the circumstances in which it is done. Says who? You start making stupid stuff, you start saying stupid stuff like this right here, and what you've done here is that you declared that the language does not mean what it says because there's wiggle room to the language. This is crazy to be saying stuff like this. And yet they're celebrating this man all of it when they're home. If he was here today, I would give him a whack on both sides of his face. I wouldn't do that because I'm not a kind of person that's advocating violence. But don't get my dandruff up over this nonsense that these persons are saying, because they have the unconstrained vision of the Constitution of the United States. And the Constitution, folks, speaks in a restrained vision. That's why shall is in the document. And I'm telling you this, the government, which is made up of and you agree with me on this, it was made up of the Article 1, Article 2, and Article 3, the three branches of government. All this other stuff that you have here that creates this bureaucracy, where you start out with, for example, 4 departments of the executive branch, and now you got 16 of them. Where did those others come from? That's part of them creating this bureaucratic nightmare that we have right now. Go look at those buildings in the nation's capital today. Every one of them a monstrosity, because it's never intended for the government to be this large. The government is the largest employer in this country, and you want to wonder why it is that you have this unrestrained government today? Are you really going to seriously ask me the question about why we have the government is out of control? Look at what the government has done, from 3 departments to this administrative state created by these people that have created the deep state. The deep state is this bureaucratic nightmare that's being created. And the onus of it now is that you got a government that has created a deficit today of $37,000 billion. They're saying now the national debt is 37 trillion. Okay, fine. But what is 37 trillion? Well, 37 trillion is 37,000 billion dollars. You understand that? For every $1 trillion is 1,000 billion dollars that they've created by this nightmare that they've created. And it would not have been created if they had not licensed this bureaucratic state to exist. So to say that they're doing things in the administrative state that's untoward, of course that's true. But the question is that you're talking about putting the cart before the horse. The horse is in front of the cart, and the horse is the fact that you have 3 branches of government, and then they created this bureaucratic nightmare by allowing itself to by creating extra constitutional laws that allow for the wiggle room they created. And now you have Jack Smith and that whole bunch. Every last one of them an outlaw. You have outlaws right now in the government. Go read, for example, the book written by what's his name? Wrote the book called I'm so agitated. Has his book out called Organized Crime, and that's written by well, anyway, it's called. Go look up Organized Crime, unraveling the truth about government, because organized crime, he's not talking about the mafia. He's talking about that which the government has created. There's a legal arm, the legal aspect of the mafia, because the mafia today is the federal government of the United States. That's what I'm saying.
They operate much the same. They use thugs to come after you if you don't give them what they want. They make you an offer you can't refuse because they got so much leverage over you. They take your money to hire goons to pressure you to do what they want you to do and give them more money. So basically, there's no difference between the mafia and the U.S. government. Yeah. There is none.
And hello, somebody. How did that happen? How did that occur of you creating a government that was intended to be small? The three articles of the government, the legislative, the executive, and the judicial, where did all this extra constitutional stuff come from in the creation of what the framers intended? It's because the intentionality of the framers has been put into exile. And that's why Dr. Thomas Woods, in his book called Who Killed the Constitution? Who did kill the Constitution? Because and also Napolitano's book, Judge Andrew Napolitano's book, The Constitution in Exile. Go read that book and ask yourself the question, who had the authority to set the Constitution aside and then bring in this other stuff here where the Constitution that's put aside doesn't apply anymore? Yeah, I agree that the administrative state is making these decisions that are untoward to what the Constitution commands. But that would not be possible if they had not given license to it by what's done by the three branches of government that's licensed the administrative state. They're the creators of it. The administrative state would not have been created in the first place if they were following the Constitution of the United States. And they cannot turn around and say, woe is me, look what we have created, and so on and so forth. Let me tell you this. An equivalent would be what they did in terms of them passing a law recently against inflation. This is absolutely absurd to pass a law against inflation when inflation is created by the ones passing the law. If you're going to pass a law against inflation, it's the equivalent of them passing a law against their own conduct, because inflation is created by the government. 2 weeks ago, John asked on the air, what percentage of inflation is created by the federal government? The answer is 100% of it is created by the federal government, because the government creates inflation. No one else can create inflation in this country except the federal government of the United States. And they do it out of the government's own cowardice. And what do you mean by that, George Moss, since you're doing all this screaming? What I mean by that is that if they paid for this bureaucracy that they've created up front, every last one of these politicians in Washington would be voted out of office. So what they do, rather than taking the bull by the horn and passing taxation to pay for the administrative state, what they do is they print more paper out here and throw it out here, weakening the dollars already in circulation, and therefore weakening those dollars and causing inflation by the fact that the dollars do not have the values that they had before the printing of those additional dollars were in fact done. And therefore, the inflation is caused by the counterfeiting of the currency. That's what inflation is. Inflation is defined as too many dollars chasing too few products. And by doing that, and making dollars, producing dollars that's not based upon production, but based upon the producing of more dollars, not producing more goods, causing that causes inflation, because the currency is increasing, but the products are not increasing. That would drive the driver of the value of the dollars. In order to stop inflation, they would have to bag out of the economy the dollars that they created. I'm telling you the truth, folks. No scholars are going to come out here and challenge it. And if they do, it's on. I guarantee it's on. Because I'm speaking on behalf of the framers, and what they're speaking is in behalf of the nonsense passed by these courts from 1919 to the present time. That's the truth as I'm sitting here. Okay, I got to get out of here. I'm doing too much shouting. Until next week, I want you to follow your dream. If you don't follow your dream, you'll never know what's on the other side of the rainbow.